My lords, I'm appearing in 801. I cannot hear anything.
Anyway, let it be in the middle of March. You have some difficulty.
Yes, madam.
Entire middle.
Yes, madam. Between 10th and 15th. Can it be
Okay, first week of March.
first week of March?
Very well, my lord. Deeply obliged.
Your Lordship, in 802, I am for the petitioner. This is the criminal appeal, Your Lordship, and this is showing in advance in that. Like,
So 2013
yes,
notice was issued on bail. What happened after that?
it was rejected, Your Lordship. Then we filed again.
Rejected. The appeal is of 2013. This one we can.
Immediately, Your Lordship.
First week of March.
Your Lordship, last week of March with the vacation.
First week of March.
My lord, permission.
Yes.
May I just mention item 51 on Monday, my lords. I have informed the other side. I'll be seeking an adjournment on that day because the arguing counsel.
When the matter is called on, we'll end.
On Monday, it's item 51. I'll just give the.
When it calls on, because
Don't need it.
Let's just to avoid any inconvenience.
you give a thank you. Mark on that.
To avoid inconvenience, I mentioned.
Thank you.
So grateful, my lords.
May I just mention, Lords? I just mentioned a matter which was listed on Tuesday as item 40, this Tuesday. The matter didn't reach, so my lord said that whatever matters that don't reach will be taken up next Tuesday. However, now the tentative date is now showing 14th February, which is also Wednesday. So in any case, it can't come
You
up.
check that.
We just have it on Tuesday, next Tuesday, as my lord said that. 6th February. I'll give the details.
Yes, call the list.
These minutes. Shocking and grave facts which had prompted the petitioner husband to file this petition will be borne from Annexure P3 of the petition, page 33.
Both are in.
I'm so obliged.
Thank you.
I'm deeply obliged. Sorry, the respondents also mischievously filed a transfer application.
Whatever, we have stayed that proceeding.
Please, I'm up.
But in item 2, my lord, is called original record, my lord.
Records have not been received yet. We'll take it on the next Friday. Records have not been received. The records have not come. List.
Please, ma'am. Well, on the last occasion, I've taken liberty to move this application.
Interim bail.
No, not interim bail, brother. This is another matter. This is the rejection of the mercy plea by one of the two petitioners before my lord.
Shankar, why don't you go to the High Court?
No, there are two petitioners. So we had gone, in fact, to the High Court in previous rounds, and the High Court had given us liberty to once again approach the authorities, which we had done only on behalf of one of the people, who is petitioner number 1. They had some slight wherewithal, they had a family, so the father has been sponsoring the litigation for petitioner 1. Petitioner 2 has absolutely no wherewithal even to file his appeal against the main judgment itself, the trial judgment.
That
So
we can direct the.
no, so both the people are before your lordship, because we have had these instances coming here before, my lords. We had given a list as well, where if there has been no application of mind at all with reference to the grant of release. Yes.
We have entertained ourselves some matters.
Yes.
But
Yes.
let us not make it the practice that
No,
32.
but here, my lord, your lordships on the last occasion had given me liberty to move an appropriate application, which is what I've done. You've given me 2 weeks. On the, if you see the order of 17th January 24,
They did not say where the application was to be filed though, Mr. Shankar
oh,
Narayan.
that is correct, my lords, but
I will give you liberty to move the High Court. Okay.
my lords,
The petitioners are before this court invoking our constitutional writ jurisdiction, invoking the constitutional writ jurisdiction under Article 32 of the Constitution. The challenge is an order. Just 1 minute. In the writ petition, the plea was for
release, page 24.
release of the petitioners under the
Because the mercy petition had not been disposed
because of pendency of their mercy petition. This is Article 72. Made under Article 72 of the Constitution of India. During pendency of this petition, the mercy plea of the first petitioner has been rejected. The said fact has been brought to our notice by an application registered as was this CRLMP or IA? What is
IA 2656,
IA number?
26562
26562
of 24,
of
2024.
2024.
No, he's challenging the
The rejection order has been assailed.
He said that.
We are of the view that the petitioners ought to approach the jurisdictional High Court, if so advised. So, in the event the petitioners are unable to obtain legal assistance on their own, we request which state is this?
It will be in Karnataka. ma'am.
We request the Karnataka State Legal Service Authority to engage a learned counsel to represent them. So, needless to add, the avenue of an petition for special leave to appeal shall still remain open in the event they are aggrieved by the decision of the Karnataka High Court.
May I make one small submission? Your lordships have left it open-ended, but because I have interim bail from your lordships on 18th May 23, would your lordship make it time-bound? On my statement, we will move the High Court within 8 weeks. That interim bail may be continued.
Please extend the interim for some
The-
period. In the meantime, let him seek relief from the High Court.
Interim
Very fair.
bail which was granted by this court on
18th May 2023,
18th May 2023.
at page 24 of the application also.
On 18th May
Yes, page 20.
2023,
Yes.
both the petitioners.
Yes.
To both the petitioners shall continue for a period of 8 weeks or until further order the High Court may pass in the writ petition should the petitioners file one or whichever is earlier.
Grateful. I may just clarify that mercy petition was on behalf of only one.
only one of
Only
the petition.
Petitioner one.
Petitioner number one.
One.
I'm grateful.
মানে রিজেক্ট হয়েছে ফাইল he was the only one to fight.
Petitioner number one's father filed it.
Huh.
But petitioner number two is only seeking early release. Premature release.
That's
He
all.
did not ask for
Yes.
mercy.
First petition has been. Read the order one.
In the recommendations, the plea was for release of the petitions.
Number one,
No.
Leave a release.
release of the petition.
Of the mercy petition.
No, because
Of the mercy
petition has stopped. At that time, the mercy petition of petitioner number one was pending.
That's correct. I'm great.
My lord, I am for the petitioner incident. Authoritative pronunciation of this court that bail condition of depositing money should not be imposed. Learned judge imposes condition to deposit 2 crores, otherwise my bail won't be considered.
See, what we'll do, we'll let us say that part of the order and directly consider. We'll set aside.
Give me 2 weeks to take instructions. The only reason is this. The parents of the petitioner have in fact fled to Dubai, which is also contained in.
You are caring for the state.
Yes, Manoj, they have fled to Dubai, and in fact, at page 26 of the charge sheet, it also indicates that there was a lookout circular. So let me just take instructions because it's extremely serious and grave if despite a lookout circular, somebody flees the country, and that is a serious consequence.
Then immigration department, sir.
So therefore, let me just take instructions.
How is that possible?
Second part is this, Manoj.
They can't live in a dhow too.
But I am inside, sir. My parents are not coming, sir. I am inside. My bail is to be considered.
We'll set aside we are not granting bail.
Because the second part is this. Because in the impugned order, the intervener had also filed an application. If my lords may just see page 1. He is the complainant. So my lords may just see page 1. It is Shakil Yusuf Jwari, who is the intervener, who is the complainant. And the SLP is not made a party.
No, he's made a party.
What may make him a party? Because I don't think he's been made a
No,
party.
he's made a party.
The SLP is only the state who's been made a party.
If we set aside the order, including the
Condition. It's then correct.
Reconsideration, that's all.
reconsideration,
Understand, Manoj?
So it will go back to the High Court. We are not deciding anything.
Yes, I understand that. But just on this question, Manoj, may consider impeaching the complainant and have it after 2 weeks.
no need of keeping it to that matter. We'll record. Stop. The petitioner is aggrieved by an order passed by the High Court consider in his plea for bail. One of the conditions imposed by the High Court for considering the prayer for bail is contained in paragraph 3 of the impugned orders, which reads : set out. The allegation against the petitioner is commission of fraud of around rupees 4 crores.
Over rupees.
Over rupees 4 crores. We are of the view that irrespective of the offense alleged from a deposit of such a high, the deposit of the sum of money was unwarranted as a condition for considering the petitioner's prayer for bail. Appearing on behalf of the state,
Two requests. My friends, Wakalatnama will come today because earlier I was there. Secondly, Millets have with SAT, I don't want to forfeit my learned friends' money. I have made a written offer after sitting with my client and I have spoken to my
Now you forfeited your
by power.
right to appear on your own.
That's why I requested my learned friend. So he will file Wakalatnama today. Can I request?
Take it on next Friday.
Is 16th possible, the Friday after that? I have made a written offer. My learned friend has
My lords, my learned friend has sent me a
list on 16.
60.
My lords, if I may just say, my lords, my learned friend, his client has sent us a offer.
Either can we see him without an advocate on record, nor we can.
No, my lords. I was just going to say, my lords, have 3 weeks because we can have them sit together and by then perhaps.
Okay, 23rd.
23rd.
Very well, my lords.
Grateful to your lord.
Grateful, my lords.
Very, very obliged.
My lord, in item 6, I'm seeking liberty to withdraw the present appeal against the law.
Withdraw.
The appeal against the same order has already been dismissed by my lord.
That's fine. That's fine.
That I mean that B.Ed matters.
23
The
also?
clarification was being sought to make it.
Both applications?
Yes, my lord. They are withdrawing, my lord.
Yes.
Both applications.
No. My application is separate. I am not
23.
23. My apologies.
6 and 23 go together.
Yeah, they would go together. I was waiting because I was given to understand that both will be taken up together.
No. Both the applications they want to withdraw.
One is my application.
Which one is yours?
23 is my application.
23 is they.
Devesh Sharviyat. My lord, it is filed, application is filed by state of MP.
My lords, consider calling 23 in its turn. Item 6 is just being withdrawn.
No, 1 minute.
No, why?
We'll pass, but
Yes,
it's
later 20.
kind of listed together. So
It is
we'll take
listed
the
together.
23.
I'll just point out, my lord, what the issue is.
1 minute. Let us see what happens. 6, huh?
6 is withdrawn.
6 he wants to withdraw.
A learned advocate appearing on behalf of the petitioner submits, he has instruction not to proceed with this petition. The present petition is dismissed as withdrawn. Interim order, if any, shall stand dissolved.
Fresh matter.
It's a fresh matter.
Item 6 is a fresh matter.
They are
There is
not
no
pressing it. There is.
Sorry, dismissed. Confusion is because 6 and 20.
Yeah, yes.
So 6 is dismissed as withdrawn.
Not 6 was by the private individuals from my lord, West Bengal. This is by the state of Madhya Pradesh.
Yes.
I just give my lord a brief background, my lord, before I take your lordships to the,
Now,
so that orally your lordships, my lord, can be briefed what the issue is. My lord, there was a circular issued by the NCTE, National Council of Technical Education, in June 18. I'm sorry, ma'am.
solicitor, would it not be better if the same bench, we can form.
I can't, my lord, argue on that.
I just want to point out one thing
Because
here.
I am not also the author of the judgment.
Justice,
May I-
Julia,
May I just point out one thing, my lords? That in two such matters which have come up, where a similar prayer has been made to make the judgment applicable prospectively, those have been rejected by this court. Number 2.
No, there are.
No, my
Levels
is
of
for whom, my lord? My learned friend is for whom?
I'm appearing for the candidates. I'm also appearing before the court in the matter
Prospect.
where the judgment.
1 minute. Prospectivity is on 2 counts. One is where the selection process has started
Yes.
and where appointments have been given.
Yes.
Sorry, well,
Possibly the judgment is silent on the point in cases where appointment has
as a
been.
matter of fact, as a matter, only a minute.
My lords, that's
Only
what
a
I
minute.
wanted to point
As a
out.
matter of, can you allow others also? We are also appearing.
Sorry, I was already.
Not, as a matter of fact, page 61, the judgment says that the concerned state did not do what we have done and therefore found at fault with. We have already made appointments as per the law applicable then.
We have not addressed directly that question.
Yes,
Pick it up.
subsequently, my lords have subsequently addressed that particular issue. Can I have a compilation here of the applications that came up before my lords, where the same prayer had been
Even do not
They are all cases where.
1 minute, can you now, I'm just.
Anyway, we'll take it up.
Yes, my lord, then my learned
My
friend,
lords,
if not
I
filed,
also want to point out one more thing.
lord, my learned friend may move an implement. Who is appearing for?
My learned friend raises an
Even
objection.
those applications were also dismissed by the same bench.
Absolutely.
So let the matter go before the same bench.
That's all.
My lords,
Why are you expending energy before this bench?
And my lord, another thing, we should know, my lord, we are opposing whom, let them file an implement if not file. And
because I was petitioned before the High Court. I am the main party.
Okay, one minute.
I don't think
Here.
learned friend is aware of what he is.
No, not
Present.
in this matter.
In this matter, also Divesh Sharma, we have a. Mr. Solicitor. My lords, I am not on an aspect. My lords are referring to another bench.
No, we are not referring to another.
My lords will hear the bench which heard the
Yes,
matter will
yes.
decide. There is no objection there, my lords. I say very well, that be so. I am on an aspect. There is a writ petition which is pending before the High Court in respect of the.
We are not going to answer that.
Yes, my lord.
My lords,
Wait.
the order that is passed on 4th of January.
We are not passing any order.
Yes, my High Court
Let-
never make my proceedings in the Supreme Court.
This application is stated before the High Court to adjourn the proceedings before the High Court.
See, that is for the High Court to take a call.
Yes, my lord.
My lords may only record this, that this application will not come in the way of.
No, my lord, that can't be. We will request that you
That
can't
is
make the
what
Supreme
we
Court
Hard.
matter infructuous.
7.
Okay. The present application
Doubt, like,
This
Registration
application
shown
is
as-
defective. Please ask your advocate on record to attend.
I apologize.
On 7th, when the matter
What
is
meant?
listed, this is what is going to be
IN
put to
number-
the High Court, that the matter is being taken up on the,
Yes,
and
yes,
that
yes.
will be adjourned. My lords,
3533 of 2024.
MA diary number. At the top. The diary number. is-
No,
Court fee has not been paid.
No, my lord. We are not
Take.
parties in the main.
That is one. The other is court fee has not been.
What we should.
by the state of Madhya Pradesh,
Madhya Pradesh.
seeking certain clarification in relation to a judgment of this court delivered by a bench comprising of one of us in bracket, that is Aniruddha Bose J and
Just Dhulia. My lord, just.
Put the full name, Sudhanshu Dhulia. The applicant was not a party to that judgment,
my lords,
having considered.
State of Madhya Pradesh, I was not a party. What?
my lords, there were applications, let my lords may not record that, because we will be able to point out that there were applications that had been filed in that matter arising
Okay,
out
no,
of
no,
cases
have not
filed
filed.
by
My
Madhya
lord,
Pradesh.
From the candidate, state was never a party. Don't mislead.
My lords, there was a notice given and an opportunity given by this court to everyone and
We
before
can
the court.
delete that.
So therefore,
We are not recording anything.
We'll show that.
Yes.
We'll argue rather than fight.
We are of the view that this application ought to be heard by the
Same permit.
by the same bench which had delivered the judgment. Let the registry constitute make the judgment.
My
Lord,
lord,
I would
my lord,
request,
this
my lord,
is
your
a
lord.
request here.
Lord, I can't scream, my lord, anyway. You complete.
I think this is.
We will sit one day around 12.
Kindly have it on Monday so that, my lord, this quarrel unnecessarily before the High Court
Okay.
is not taking place. That's all I was going to say.
I cannot take unilateral decision. I discuss it will be on the.
Yes, yes, my lord, kindly.
My lords, only that is the request if my lords. can
Monday
please-
or Tuesday will fit.
I am.
Yes, sir.
That is all. Matter before the High Court is on 8th of February. If my lords can take it up before that,
The
that
High
will
Court
be very
cannot
great.
make Supreme Court proceedings infructuous. That's very clear. Then.
Yes.
Don't need argument.
Deeply grateful.
Item 7.
Issue notice.
No difficulty. But there is another petition also, same order, 51183 of 23. Diary number 5118, that's not shown. My lord sees page A1 at the bottom. You have mentioned that. Arising out of the same order, there are two petitions.
Yes. That's not been numbered
That's
yet.
not, no, both the matters were not numbered because there was a delay of some 5-6 days for
also bad.
refiling. That delay will have to be condoned.
Issue notice to be listed along with the.
But that second matter is not listed at all. That will have to be taken upon.
Then issue notice. Let us remain. Leave at that.
You can ask for that to be clubbed.
Please.
Issue notice.
Only one thing,
17
not,
days.
no execution proceedings.
Stop the video. Issue notice returnable 3 weeks since. Let service by Dusty in addition to the regular mode until the next date of hearing. Let what is the execution proceeding?
The recovery certificate of an amount.
No.
So, not to execute a recovery certificate.
Has it?
Well, that's on page 66. That's the recovery certificate.
Page?
That's the order of the assistant registrar.
Let the let the recovery proceeding forming subject matter of this petition remain state.
Please.
There is a delay in the days, but this is a case of complete fraud, my lord. In 1958, my lord, the property is acquired, my lord.
How much is acquired? That is the whole point.
The entire thing. This
1.45.
my lord, lordship will see, my lord, there are two acquisitions.
You have a document showing
Yes.
that we acquired the entire
Absolutely.
5.79
My
acres.
lord, two,
Where is the
two submissions, my lord. There were two acquisitions. One, of course, where the lesser extent was acquired, about 4 acres. Subsequently, lordships will see, my lord, the award.
The
Award at page,
quotas
yes, my lord, at,
divided 4.35 and
at page 53, lordship will see the award.
Your MRO's report is also.
No, my lord, lordships will see the award. My lord, unfortunately, these documents were not before the trial court. We sought, my lord, we discovered these documents much later. Yes, we have been lax. But the award is there, my lord, his letter is there. Lordship will see at page 53.
No, did you ultimately?
Yes, we produced it before the Honorable High Court. High Court has considered, but they have said that actually, yes, you may have acquired it, but because you have not shown that the compensation is actually paid, therefore, we will not come to your rescue. My lord, that after 58, my lord, yes, we have been lax, my lord, we should have produced these documents at an earlier stage. But today, my lord, somebody who has given an undertaking, yes, please take my land. Lordships have had
Have proof of payment of the company.
only that. Everything, the award is there, his undertaking is there, handover, everything is there of 58, my lord. And this very gentleman who files the suit.
R3 in the
You are for?
R3, respondent number 3.
Acha, notice returnable 2 weeks since.
In the meanwhile, Lordship may direct.
Service by regular service by Dusty in addition to regular mode. Respondent number 3, however, appears on caveat.
Yes, I'm okay.
On caveat and accept notice on through his learned advocate. Hence, formal service of notice on the respondent number 3 shall stand dispensed.
Right.
Right, please. Item 9. Limitation Act does not apply to the execution of orders for permanent injunction and perpetual injunction. The annexure P2, which the petitioner sought to be enforced, is a permanent injunction. The Honorable High Court non-suited me on 2 grounds. Number 1, delay in filing execution. And number 2, the High Court relied upon alleged compromise deed, which was never placed on record in any proceeding before any court below. In fact,
Para 7 of the judgment.
No, why are you saying Limitation Act won't apply?
Because
it can be a continuous cause of action, but Limitation Act will apply. Huh?
Para 7.
High Court.
for
Para 7, look at para 7.
Para 7 of the impugned order.
It is not disputed between the parties that their predecessor had voluntarily entered into the compromise.
That is
not
a wrong,
disputed.
That is a wrong submission.
Then you have to get it corrected.
By
going to the High Court all along.
Well, the High Court seems to proceed on the assumption that you never disputed it.
In fact, would my lord see one more page?
Which is what you were saying before us. But
Yes.
this order reads to the contrary.
There was no, because after, if there was a.
You will have to go by what the High Court order records, that you did not dispute it. So if you are saying that the High Court made a wrong recording of fact, then you go back to the High Court, get this corrected first.
That apart, leaving that apart, on law, if the High Court has also non-suited me on limitation.
See, first, let this.
They both go together. The High Court takes the fact into consideration that you entered into a compromise, you acted on it. For 16 years, you used that alternative path. And now you want to go back to this path because your father died. This is how the High Court understands. You, on the other hand, say that they allowed you to use the main path till your father died. And now you're being prevented. That's why you filed the exclusion.
Lordship, that main path, the path of.
Till this is corrected, counsel, we can't proceed. We'll have to go by what the High Court records, that you admitted before the High Court that there is a compromise. Once you admit that there is a compromise, if you take this to be true, that means that you acted upon it. Which also means that you are now trying to outdo that compromise by falling back on a 1997 order after 16 years. So the whole thing becomes rather complicated. So unless you get this corrected, we can't proceed.
Would my lord pass over this for a.
No, why pass over?
I'll take instruction.
What instruction is recorded? The order impugned in this petition proceeds on the basis that the parties that the predecessors of the parties had voluntarily entered into a compromise on 11th December 1997 and acted upon the said compromise in modification of an earlier order dated 26th November 1997 passed by the Malmatdar Mandal. So, learned counsel appearing for the petitioner submits that this is a wrong recordal of fact. So, if that is the case, then the petitioner ought to approach the High Court for he's not saying as a review or anything. Stop. With the liberty to the petitioner to approach the High Court, we dismiss the present petition.
Also, with the liberty to come back to the this honorable court with a
Yeah,
fresh,
not said whether review or what.
because
If
then
it's a wrong record, it will not be review. Read better.
because that order may again come in by way approaching this honorable court, because once the SLP is dismissed.
The scope of filing a further petition before this court is kept open, comma, should the petition file an appropriate application before the High Court and fail in that petition.
But
Should I appear on the?
There are 3 concurrent orders against me. I am for the tenant. So, but there was only one point which, if your lordships, I can say before your lordships, that there is no.
You're only aggrieved by the mean profits or against the order of eviction?
Eviction also, madam. Eviction also. There was a no written.
Dismiss.
Wait. Obliged.
Lord, I beg to appear, my Lord, on behalf of the petitioner for Operation Balloon. Lord, the suit was decreed, my Lord, that the entire scheduled property originally was.
The question was intended for you.
I'm sorry.
Are you aggrieved only by the mean profits? Or
Only mean profits, my Lord. Possession has been handed over, my Lord, of the balance portion.
I only say
Lord, just give me a minute. Let me complete, then you can. Just give me a minute, my Lord. Just give me a minute. My Lord, if your Lordship has the trial court judgment for a minute, my Lord, please have a look at, my Lord, page 118. Because this would be giving them another opportunity. Now, if your Lordship sees issue number 6 and 7 was specifically framed for mean profits, they laid no evidence, is what the trial judge says. Please have a look at 118.
now the inquiry is to be made.
No, my Lord.
The High Court says an inquiry will be made now.
What I'm saying is, my Lord, specifically issues were framed.
This is the usual dignity of mean profit. Yes.
My Lord, they didn't lead any evidence on mean profits.
They will.
That's what I wanted to say. Have a look at the issues, my Lord.
There will be a decree for mean profits.
No, my Lord, this is
delegated to an inquiry.
Sorry.
The High Court. My Lord, that's what the High
Not
Court
been
said.
paying anything since 2009.
My Lord, he is not accepting. What can I do, my Lord?
You want to pay some paltry rent amount.
Sorry.
Like. But I was
Relay
before the first applied court, my lord. In fact, my lord, that whatever the finding of fact which has been given, my lord, that is a final in the first applied court under section 96 CPC, my lord. The High Court, my lord, kindly see, my lord, page number 16. What is the logic given, my lord? Lordship may kindly see, my lord, page number 16. The logic given, my lord, enter into the that question of fact.
High Court has come from the trial court.
The reason for that, my lord, reversing the first applied court. Lordship got it.
16.
Right, to start with, it prefers the approach also. To start with, it is proved that the plaintiff is illiterate. That is the logic which has been said, manner. For that, the reasoning given, manner. Indeed, Exhibit A to B1 shows that the plaintiff has only fixed a mark in the document and did not sign, manner. This is the one. So, because of he is not signed, therefore, thumb impression, therefore, this one. Then, the plaintiff is a woman of poor intelligence and inadequate. Comprehensive in proved through PW2 and PW3. So, my lord, the reasoning is given.
Lordship, so we are all sisters, my lord. Because the property she herself came and executed the partition deed, my lord. What remains, my lord?
Sorry, next matter.
Great.
Delay of 200.
Delay of 200 days, delay. Start with that first.
Sorry, my lord.
What little relief you can get also you don't want.
50% we succeed, my lord. Grateful. I'm so.
Please, ma'am. The execution of the agreement is admitted. The receipt of money is admitted. But now the High Court has non-suited me on the basis of an evidence which is otherwise has to be excluded under Section 94 Evidence Act. My lord, alienation only.
Notice the returnable 3 weeks since. Let us see.
Yes.
May I teach my High Court has applied wrong law. High Court has applied old law. The father, the property devolved upon father would be his individual property. Even High Court has cited this judgment, Commissioner of Wealth Tax versus Chandar Sen, but had taken a different analogy. It would be his individual property, therefore he could have.
No, devolved in what manner? From the
by partition.
By partition, where do we get that?
That is the evidence of PW1 itself.
No, was that evidence accepted?
This PW1, plaintiff himself is saying it was partition, its share was given to father. Shell deed was executed in.
We are issuing notice. We have not dismissed.
We are in.
Was item 15, my lords, I'm being read by Mr. Raja Aditya, my lords. He may be unmuted, my lords.
For serial number 15, my lord, for petitioner. Am I audible, my lord? Am I audible?
Evidence, we won't interfere. Dismiss.
My lord, the fourth time it has been reopened, and that too without even mentioning what
These are
is
also
the.
courts. Some latitude should be given to them.
My lord, fourth time it is, and
Because
7
we are
years they've taken for.
You said it's the third time, is it?
It's the fourth time that they've already reopened it 3 times. This is the fourth time that they are reopening it, and they have taken 7 years to complete their chief evidence.
Them have been dragging on the proceedings is
And-
what I'll.
The Honorable Trial Court has come down heavily upon the respondents for dealing and not even mentioning what is the document and what is the relevance and why they could not produce it earlier. The trial court has come down heavily upon the respondents. For
How the
dealing
trial is conducted, we won't interfere with that.
The only reasoning given by trial court is that I am not prejudiced, my lord. My lord, reopening of the evidence multiple times, fourth time, that too a 10-year-old suit.
How will it, except delay the proceeding, it material loss? Yes. Next matter.
This is a 100-year school, man. Not to be evicted on the at the behest of a mahant. My lord, this was my lord. What happens? It was a my lord. I may say in our state, man. There used to be rajas. They used to give some land to the temple, some land to the school. They were very progressive that they, apart from temples, which is also important.
But you paid rent to the temple.
No, the whole idea was that this temple deity, what they were internal arrangements prior to independence.
But all
that
these
some
points you didn't take before.
No, the High Court has, kindly see the writ petition. We have taken every point. High Court has said,
From the rent receipt.
From 1963.
But if you allowed that
No, my lord.
to show it as a rental payment.
Correct. How it happens? In 1963, there is a school inspector. My lord, these
If the state is so much against, state can acquire the land.
No, my lord, but this is not the point. My lord, this is 100. My lord, school is running there for 100 years, my lord. And the folklore is, my lord, that my lord, they want to they will make a mall out of it, my lord. My lord, local, my lord, this is a school of more than 100-year-old, my lord.
Just two issues, if I may just point out. They have never questioned the title of the deity insofar as, my lords, them, the relationship between them and ourselves being that of landlord and tenant.
We are challenging it.
My lords, that itself, my lords, once there is a question to the title of the landlord, my lords, that itself is a ground for eviction. Now they continue to pay rent, my lords. They have never questioned that why they're paying rent to us.
One should not be a party, only the.
My lords,
and he's not a trustee. Till today is not a trustee.
Only
my lords,
yes.
Plaintiff number 2, my lords.
He cannot represent them. The present president is not a trustee. Kindly turn.
To that limited extent, the High Court had asked us to file an affidavit.
No.
A specific affidavit was filed.
Wrong affidavit. Wrong affidavit.
Notice stay.
Oblige.
Stay of the impugned order.
Oblige.
Acha, you appear for?
My lords, both the respondents.
You are Mr.
Paul, my lords. A. Paul.
The existence of the trust is also an issue because
Yes,
he went
yes.
before the rent controller and said there's no trust at all.
Yes. Trust is fall. He's not the trust.
That was after my father expired.
Yes, on caveat.
Seem to be some doubtful issues here.
If you notice, there shall be a stay of the impugned judgment and order until the returnable date. The respondents are represented through their counsel on caveat. Mr. Paul appearing. Who is your advocate on record?
Mr. Matolia.
Mr. Matolia. Mr. Matolia accept notice on behalf of the said respondents. Hence, formal service of notice on the respondents dispensed with, list the matter after 4 weeks. Counter affidavit may be filed in the meantime.
Oblige.
What is the rate?
107 rupees, my lords, which is the money is to be used for the daily bhog of the deity, my lords.
I didn't want to say he is the person who has sold the entire land of this playground also. And my lord, he is the person who is constructing shops all around. He is not a temple, my lord. These are the issues I didn't want to go into.
Well, let's, we have,
yes, my lord, this is a serious issue about this man, my lord. Yes,
yes, next matter.
So 1917, I'm requesting for a Passover.
Passover is next day. Accommodation is asked for on behalf of the petitioner. List after 1 week.
Not in 18, not there are 2 written statements on record, my lords. I'm illiterate person and not. The problem is, my lords, I'm just seeking additional evidence to be led, my lords. What prejudice would be caused? Let me just record my evidence, my lord. They can cross-examine me. What prejudice would be caused, my lord? My lords, even order 1817 says that court may recall not 2 written statements, contradictory written statements.
So many things you are.
Let's look at the conduct, my lords. I don't want to get dismissed.
My lords, they can cross-examine you. My lords, what harm? Let's look at my
Want the wakalat of the advocate to be rejected.
My lords, I understand that's not happily the drafted application.
How many prayers are there?
Clear case where the admission is sought to be resigned from, my lord. Clear case.
My lords, there is a written statement.
Anyway, we are.
My lords,
yes,
my lords, just for 1 minute, my lords. my mother says in my favor, my lord, the witnesses to the.
We are not examining.
My lord,
that.
this
Yes.
is
Next matter.
my lord, may I just say one thing, Lord, dismissal of the SFT may not come in the trial of the, in deciding the trial of the.
We are not saying anything. We are just
My lord,
discussing.
then they will say the Supreme
Oh,
Court.
we'll give you a chance to withdraw.
Lord, then Lord, I will.
Okay. The petition is dismissed as withdrawn.
Much.
The petitioner is actually a victim of it. The brother and sisters together, after paying 25 lakhs, he purchased. After 4 years, they challenged, saying that the brother had no authority. He is a victim. Yes. Lordship, this one is not concurrent funding and this deserves notice, Lordship, because it was a declaration suit by me. My my grandfather's son is questioning it actually. I filed a declaration suit. Kindly peruse this one. All entries.
And so many names are repeated and.
Yes, that is why I had such a difficulty there. In the
Basappa, which one is?
Lordship, there are 3 Basappas, 3 Burmappas. I had to say Burmappa 1, Burmappa 2, and I
Anyway, should notice.
Please, the status quo.
No need of status quo.
Lordship, because declaration suit, otherwise they will.
What will they do? It will be subject to whatever we say.
Oblige.
Please, Your Lordship. Elections which are to be held on the 5th of February.
I am on caveat.
Matter is pending.
Matter is pending, my lord, but stay, there is no reason assigned at all for granting a stay.
My lord, I have.
Kumar, if an appeal lies before the division bench, how can you come to this court?
It was stayed till 18 January 2024.
Yes, my lord. And 5th February, the Monday is the election. That's the date of the election, my lord.
That's incorrect, my lord.
I have annexed the copy of the.
It's supposed to come on
2nd February.
Supposed to come today.
Yes, my
It
lord.
is listed today, my lord.
Yes, my lord.
If my friend doesn't mind, let him argue, my lord. I don't want.
Still on vacation?
My lord, this is the complete order sheet, the certified copy, which has not been provided by the learned counsel for the petitioner, my lord.
Has the court reopened or is it?
No, it's going to open on the 10th, my lord. After the 10th.
Second, were you?
So today the matter will come up for the learned.
Today's matter is listed, my lord. But
it has been listed.
My lord,
it is listed. It is item 32 listed today before the learned vacation judge, even today, my lord.
Then why don't you follow up there?
No, we are following up there, my lord, but I am saying elections are on Monday. Now question.
Let them know.
You want to argue Punnuswamy there? You go take up Punnuswamy and educate the High Court about what
There is a section, my lord, and your
Court
lord
said in 1950.
are there.
my lord, the complete order sheet has not been provided.
You may be on caveat, but unless we are
I'm so
inclined to grant an order, you have no right of audience.
I'm so sorry, my lord. I'm so sorry.
Your lordship may, my lord, may I request that your lordship may keep this back, my lord, for 1 week?
No.
If your lordship don't mind, because what would happen is, any dismissal here.
You will also have to find out why an appeal bench has not been provided. Normally during the vacations, there would be at least.
I bow down to that observation, my lord, absolutely.
They have enough number of judges.
Yes, my lord, they do have, and there should be a division bench, my lord. But I am instructed to say that there is no division bench. And that's how, my lord, and the court will reopen on the 12th, Monday the 12th. A dismissal will not affect my, as if, my lord, that your lordships are decided.
Withdraw it, Mr.
No, then lordships may only say, my lord, that because the matter is listed today, we are not.
1 minute. We are apprised by Mr. Ranjit Kumar, Learned Senior Counsel, that in the High Court, The matter is listed today itself.
Therefore, I am withdrawing it, my lord.
And for that reason, he doesn't want to proceed with the matter. The present petition is accordingly dismissed as withdrawn.
Very obliged.
फोटो करो ना, फोटो तो चालू करो.
आवाज तो बंद रखो.
आवाज
वो अपने आप
नहीं, मैंने यहाँ से ही बंद कर रखी है. चालू वहां से चालू करो, हल्की कर दो वो. अब यार माइल हमारा उनका चल रहा है.
इसमें तो दिखाऊंगा.
इसकी आवाज तो पूरी है ना.
हाँ, इसकी पूरी.
देख लो.
हाँ हाँ.
मेरी जो भेजती हो मेल से भी तुम्हें कर सकते हो.
वजन तेज कर देना जब मांगे. वो कौन सा चल रहा है उसमें?
इसके बाद ही आपको
आज आदमी देखते रहे. ये 15. My lord, I am appearing in item number 22.
Yes.
My lord, this is a petition by a widow tenant who were there for since 50 years, and she is having conflict, my lord. So 1 year time was sought for vacating. 1 month was given time. So this is that 1 year if it can be granted, my lord.
So Agarwal, we have full sympathy, but no law. Dismissed.
No, my lord, the time lordship have full power regarding
sympathy for your client, but
not
what
on
to
law,
do?
my lord.
Sorry,
6
Mr.
months,
Agarwal.
my lord, 6 months can be granted.
No further time.
Oh.
Says he's been tried for the same offense for the actual courts.
24
in Delhi.
Next matter.
24. 24, no one?
So Agarwal, we have dismissed your matter. Yes, sorry. Yes, next matter.
24, there's no one.
No offense.
None appears. Shall we dismiss for no prosecution?
Delay is also 1,016 days.
Dismiss.
Hey, please, Lord. Sorry, I was
24.
confused. I was confused because it is 25.
Yes.
I'm on two grounds, Your Lordship. That one is that I was not in conscious possession of the contraband, and
So
the
that is on fact. You don't entertain that argument. What's the other point?
the argument that there is another case arising out of the same source, and that was held in we were
Arising out of same recovery or seizure.
there were two recoveries, one in Delhi and one in UP. So, but those two recoveries are arising out of the same source because we got 3 consignments to book. 2 we already booked, and then
Admitting everything now.
So one is
not admitting at all because that is already on the record. That is already on the record, Your Lordship.
No, but if there were recoveries at 2 places, each recovery would give rise to the cause of action there.
What we are
How do you say that double jeopardy applies?
Double jeopardy, because Your Lordship, we are not contending that there were 2 offences. What we are contending is that I was 19 years old when I got into this case, and I got information that we are supposed to deliver these 3